Good morning. This is Immigration Attorney William Kovatch, and today we're going to talk about corroboration, particularly as it applies to asylum application. Now, what is corroboration and why should you worry about it? The fact of the matter is, well, corroboration basically means evidence that supports your claim, evidence that supports, for example, your asylum application. And why you should worry about it is because the law does create an obligation to submit as much corroborating evidence of your claim that is reasonably available to you. Now, it is certainly possible that an immigration judge, after hearing your testimony, can approve your claim based solely on your credible testimony. Hey, this particular respondent was credible. I believe the story. Therefore, I'm going to grant the application for asylum. That can happen. Typically, that's not what does happen, however. Judges want to see the corroborating evidence. They want to see the evidence that supports your claim. What is corroborating evidence? First, we're looking for primary evidence. For example, if you've reported a problem to the police, we want to see police reports. If you've had injuries because of the past persecution or being harmed by somebody, we want to see medical records. Have you gone to the doctor? Did you take pictures? Did you take pictures of the injury? And then other forms of corroborating evidence. Do you have letters or affidavits from people who witnessed the crime or people who are somehow involved in your case? Maybe after you decided that it was time to flee your country and come to the United States, you stayed with somebody for a period of time and that person knows a little bit about your case. Those are the types of things we're looking for in corroborating evidence. We may also want to look for things like maps. Let's say, for example, that you went to a medical facility or you're arguing that the medical facility or the police department is far from you. The closest one is really far from you. We may need to see some maps so that we can establish for the judge just how far this was and how it wasn't reasonable for you to go to that medical facility or go to see the police officers. When you're getting corroborating evidence from witnesses, when you're getting letters from witnesses, one of the biggest mistakes I see are these letters or affidavits that basically say very general things. So-and-so should be allowed to immigrate to the United States because they're having problems with the gangs here in Central America. I've seen that a lot. And the thing is this, those types of corroborating evidence are not very useful at all. In part because what you're trying to do in an asylum case is you're trying to set you apart from most of the rest of society. That's because asylum is not meant to give protection over general criminality issues. Asylum is meant to be protection against persecution based on one of the 5 protected reasons: race, religion, nationality, political opinion, or membership in a particular social group. So if you're giving me an affidavit that just says, well, she has to escape the gangs, that doesn't really distinguish your case from some other case or some other person who is also facing gang violence in your home country. So we want to see something that's detailed, something that gives us the particulars of the persecution you suffered, of the people who are harming you or the people who are threatening to harm you. And we want to see something more than just, oh, we're afraid because of the gangs. We want to see, well, why are the gangs targeting you? Why did you have to leave your country? Typically, if you're going into any place but the Ninth Circuit, any court that's in any U.S. circuit but the Ninth Circuit, you should make sure you have all of your corroborating evidence up front. The judges, as I said, they may approve your case based on your testimony alone. The way the statute is written, they are supposed to give you an opportunity. If they don't approve your case based on your testimony alone, they're supposed to give you the reasons why, explain to you the corroborating evidence that they need, and give you an opportunity to go and obtain that evidence. But in reality, that's not how it works in most courts. In most courts, you need to have that corroborating evidence up front. You need to be able to foresee what you're going to need and what you're going to need to do to convince the judge. The Ninth Circuit, as I said, is the exception here. There is a case, excuse me, there is a case in the Ninth Circuit that does require an immigration judge to tell you why they don't believe your story, why they're having problems with your credibility, and to give you a list. These are the types of evidence that we want to see in order to corroborate your case. So if you're not in the Ninth Circuit, You need to do it up front. If you're in the Ninth Circuit, it's still best practice to put as much evidence in the application and before the merits hearing as possible. So I hope this video has been useful to you. I hope it gives you a little bit of a guidance of how you should prepare your case for an application, an asylum application. If you like this video, give me a thumbs up. Leave your comments below. If you want to see more videos like this, by all means, please subscribe to my channel. If you have any questions about immigration law, or if you want to make an appointment to come see me for an immigration question, give me a call at 703-837-8832. That's 703-837-8832. Thank you.